All right, in news just coming in, the Supreme Court of India judges are reading out the judgment on the petition challenging the adultery law. Chief Justice of India, Deepak Mishra, has said that women must be treated with equality. That's the news breaking here on Beyond This Moment. The judges are reading out the judgment as we speak on petitions challenging the Victorian-era adultery law in India. And Chief Justice Deepak Mishra saying that women must be treated with equality. All right, joining me now from the Beyond newsroom is Beyond's very own Karthikeya Sharma. Karthikeya, good morning. Take us through the import of what the justice said there.
Morning, Ramesh. It's a very important judgment which is in the process of being announced. The judgment or the verdict is on adultery. Now, adultery is a reflection of Victorian morality. Adultery was a law made during colonial times. It made sub judice a relationship between a married man and a married woman, or a person who has a relationship outside marriage. But it was not gender neutral, because at that point of time, and even today under sort of patriarchal mentality, women are considered to be subjects, or women are considered to be some sort of property to be transferred. For example, you find notions of it even in the larger Sanatan Dharma, which is also known as Stridhan. But sticking to the particular context in which this verdict is being read out, in all probability, court is all set to decriminalize adultery. Adultery in India may remain a ground for divorce, but it will not be, you will not be able to file a charge sheet against a man. You will not be able to take a person to court on this issue, because this law finds not only reflection in the relationship which we find in civil society, but even if you look at the colonial laws and army and navy, we find reflection of this law. For particular, I would say that there is a law in our armed forces which is called stealing affection of fellow officer's wife. People have lost jobs there, but the reasoning is that army is about brotherhood. It's a contained community and the laws will be different. So I really do not know whether this law will be amended or treated separately when it comes to armed forces or institutions. But for civil society at large, adultery will not remain a crime. It's a Victorian law which in all probability is said to be annulled. Look at the comments which judges are making. The judge is saying the beauty of Indian Constitution is that it introduces I, you and me. Women not being treated with dignity have always invited the wrath of the Constitution. It also goes on to say, Ramesh, that equality is the governing parameter. Wife and mother don't work by the clock. They take care of the husband and children, provide invaluable service to them. And then it says, Section 497 is manifestly arbitrary and offends the dignity of a woman. And taking consent of the husband tantamounts to subordination of the woman. Adultery cannot be a criminal offense. This is part of the verdict. Obviously, we know where the verdict is heading, so I will not dare prejudge what judges are going to say. But this verdict is not political. This verdict is about gender neutrality. This verdict is about not to treat women like subject. This verdict is going to be about equality of men and women. This verdict is also going to be about doing away of Victorian laws. And this verdict will also be about not treating women as the word, before 1947, the chattel which was used. So this verdict is going to be path-breaking, because there are certain laws in which men and women, in terms of personal and public law, were treated differently. They were not only treated differently, but certain different yardsticks were applied. So going by the statements which are coming out, I believe that it's going to go the same path as we are thinking. This law, 497 section, Ramesh, was drafted in 1860. Now 1860 is 3 years after 1857. When the Crown took over the assets of, the companies of merchant which actually annexed India 100 years ago after Battle of Plassey. And then they came out with the law, and at that point of time, Ramesh, adultery, people could have been jailed for 4 to 5 years. And this law further got elaborated, and it was also incorporated when the new constitution came into effect in colonial times through the Act of 1935. So that way it has also seen evolution in terms of its reach during colonial times. So this is fundamentally a very, very reformative step, which I think the courts will take, Ramesh.
Indeed. Karthikeya, do stay on if you will. I want to remind our viewers that the Chief Justice is still reading the judgment as we speak. As Karthikeya pointed out, the Chief Justice Deepak Mishra is saying that the Victorian era adultery law is arbitrary, offends the dignity of women, and that women must be treated with equality, and that adultery cannot be a criminal offense. Now, that's the news we are tracking here on Beyond This Moment. As you can see on your screens right now, the Supreme Court is reading out its judgment on adultery law, and Chief Justice of India Deepak Mishra is saying that the Victorian era law is arbitrary and offends the dignity of women, and that women must be treated with equality, and adultery is not a criminal offense. Right, so if I can go back to my colleague Karthikeya Sharma one more time. Karthikeya, now the law defines adultery as offense committed by a man if he has sexual relations with a married woman without her husband's consent. At the same time, a married man held guilty of adultery is liable to a jail term of up to 5 years. So are we looking at how the activists are hoping that the court will strike down the Victorian era law, which considers women as a husband's property?
Absolutely. Taking off from where you ended, my understanding is that it is in principle, which judges are saying is violative of Article 21 of the Indian Constitution. Now, the Chief Justice of India, Mr. Mishra, is saying that the legal sovereignty of one sex over another is wrong. It's a very important statement. You see, this is not an observation. He's reading out a verdict. And then Mr. Mishra also says any system or law which affects individual dignity of women in a civilized society invites the wrath, as you mentioned to our viewers. Now, he also says the IPC affects the right to life of a woman under Article 21 of the Indian Constitution, which means if anything goes against the basic structure of the Constitution, obviously it will not be able to uphold the judicial scrutiny. So, these are early indications as to where the matter is going to go. So, the judge himself is saying that it is violative of Article 21 of the Constitution. But he admits, Ramesh, that adultery can be a ground for divorce, but cannot be a criminal offense. This is what Mishra is reading, Justice Mishra, that adultery can be a ground for divorce, but adultery cannot be a criminal offense. And he says that adultery is associated with institution of marriage, and Parliament made laws to protect the right of the women, and then so on and so forth. But my understanding is that somehow, fundamentally, now the Chief Justice of India, who is reading his verdict, is of the view that it's incompatible with the certain provisions of basic structure of the Constitution, which is Article 21. It is not compatible at all. It's not compatible in context of sense of equality, which is instilled in our Constitution, in context of gender. He also says it's incompatible in terms of power relationship, where both men and women are considered to be equal. And secondly, it's a colonial law. Let's not even talk about gender equality. You are criminalizing certain aspects of social relationships. Adultery, yes. It violates certain, it's like violation of the sacred trust of marriage. But the issue is, do you criminalize it? And do you criminalize it from the perspective of a man? Because when you do that, Ramesh, you say that the woman is like a property. So if man allows a relationship, it's not adultery. If man does not do it, it becomes an adultery. Then there are also gray areas. Suppose the another man is not married. So, these are legal nitty-gritties, but broadly, it is about how women are supposed to be placed in your society and civic life. Our civic life, our ethics, our law flows from the constitutional morality. And my understanding from the observation of the judges is that judges are of the view that this law, archaic Victorian law, violates the constitutional morality.
Right, Karthikeya, stay on if you will. We're now joined by Justice Mukul Mudgal, retired, who joins us from New Delhi. Justice Mudgal, thank you for joining us on Beyond This Morning. Now, we are told that 2 of the 5 judges have read out their judgments. We are waiting for the remaining 3 judges to also read out their judgments if they indeed do. But the main thrust of the argument put forth by the Chief Justice, Justice Deepak Mishra, is that the Victorian era law on adultery is arbitrary it offends the dignity of women, and that women must be treated with equality, and that adultery cannot be a criminal offence. Your thoughts, Justice Mudgal?
I think the view is absolutely correct. There cannot be a kind of a reverse discrimination against men on this issue. Look, these laws were enacted, most of these laws are very, very Victorian model, as you rightly said. But today, there should be equality, and we should live in the modern times, when what two adults relationship is no part of anybody's business. That's my view on this.
Right, Justice Mudgal, do stay on. I want to recap for the benefit of our viewers what this complex adultery law is all about. Now, as it stands, the law penalizes men who are found engaging in adultery, although women are immune from such punishment. Now, further, if the husband of the woman gives his consent for the wife to have sex with another man, no offence lies. The law identifies the married man as the victim. Further, it does not give any right to a woman to prosecute a husband should he be in an adulterous relationship. In this backdrop, the petition prompted the court to revisit whether the section was liable to be struck down for being violative of gender equality. Now, while it was framed under British rule in India, adultery is no longer a crime in England. Among other countries, adultery is a crime in Pakistan and can invite a maximum penalty of death. In Saudi Arabia, adulterers can be stoned to death. In the US, for instance, 21 states regard adultery as a criminal act. So that's the context in which one should locate the Supreme Court verdict, which is being read as we speak, with Chief Justice Deepak Mishra reading out the second of the 5-judge bench verdict. And Justice Mishra saying that the Victorian-era law is arbitrary and it offends the dignity of the woman, and that women must be treated with equality. All right, if Justice Mudgal is still with us. Justice Mudgal, for the benefit of viewers who might not be familiar with the intricacies of this so-called Victorian-era law, could you demystify the implications of this 100-plus-year law for the Indian citizens as we speak, and the import of this verdict on them?
Look, it would be if a man were to have relations with a married woman, then he is guilty of adultery. This is the law. The reverse is not true. All right?
All right. Yeah, carry on.
If the woman has a relationship with a married man, that is not an offense. Who's not married. That's my view. Okay?
Sure, please carry on.
I think it's better that we read section. Let me get hold of the section, please. 1 minute.
Sure.
Just talk to the others. I'll get back to you.
All right. Appreciate it, Justice Mudgal. If I can go back to my colleague Karthikeya Sharma one more time. Karthikeya, take us with the latest you're hearing from the Supreme Court.
You see, the latest which we are getting is because number of judges are reading it simultaneously. You know the view, Ramesh, of the Chief Justice of India. We discussed it earlier. Even Justice Rohinton Nariman says that Section 497 violates Article 14 and 15. So, this is a very important point, Ramesh, which is being made, that justice after justice, they are saying that the basic principle of the Constitution is being violated. That is very, very important. Then Section 497 IPC and 498 CRPC unconstitutional, which Chief Justice of India Deepak Mishra on behalf of himself and Mr. Khanwilkar has said. So out of 4, 3 judges have already said that it's not constitutional. So I will not use the word, well, it's out till they say, that's what the verdict is. But we know where the verdict is going to go. It's very, very clear from now, because out of the 4, 3 have already categorically said that it is violative of Article 14 and 15. So when we say Article 14 and 15, under Keshwanand Bharti judgment, there is something called basic structure of the constitution. It's the only time where judiciary had intervened when there was a legislative outreach, and it was decided in India that legislature can make laws when it comes to constitution, but it cannot tamper with the basic structure of constitution in India. So now my understanding is when they say it's violated of 14 and 15, which is going against the grain of the basic structure, one. Secondly, this judgment is on the gender neutrality. This verdict is also about doing away of certain archaic laws which we have inherited, because certain reforms in the criminal procedure law has not taken place, Krishna. And I would say that the important part is if you read what the Chief Justice said, he said Section 497 gives husband the exclusive right to prosecute his wife's lover. A similar right is not conferred on a wife to prosecute the woman with whom her husband has committed adultery. Secondly, the provision does not confer any right on the wife to prosecute her husband for adultery. Further, the law does not take into account cases where the husband has sexual relations with an unmarried woman. So, judges have actually gone very, very deep into this issue. And now, Justice Chandrachud is in news. Justice Chandrachud was in news yesterday also.
Yes.
Justice Chandrachud has said Section 497 deprives women of autonomy. So I think all the judges of this bench do agree that somehow it infringes on the dignity, autonomy, right of women of this country. Now, before I get into certain details, I would like to share with you that it's not as if adultery is something very specific to India. It has taken Western nations to repeal adultery. They took their own time. For example, in Italy it was repealed in 1969. In Malta it was repealed in 1973. Luxembourg repealed the law on adultery in 1974. In France it was repealed, Krishna, in 1975. In Spain it was 1978. In Portugal it was 1982. In Greece it was 1983. In Belgium it was 1987, in Switzerland it was 1989, and in Austria it was 1997. So even European countries, which is supposed to be the beacon light when it comes to certain fundamental, I would say, elements of parliamentary democracy, which is fraternity, equality, they have taken their own time. Now even Latin American countries have taken their own time. Paraguay did away with the law of adultery in 1990, Chile in 1994, Argentina in 1995, Nicaragua in 1996, the Dominican Republic in 1997, Brazil in 2005, Haiti in 2005. In Australia, adultery is not a crime. So today, adultery is a crime in Taiwan and Philippines, but adultery is not a crime in Japan and South Korea. Adultery is not a crime in People's Republic of China, but it's a ground for divorce. In Pakistan, adultery is a crime under the Hudud Ordinance promulgated in 1979 when General Zia took over power. He Islamicized the law framework of the Pakistan. In India, it continues.
Right.
I don't know what will happen in the next 5 minutes,
right,
but it continues to be illegal, but in all likelihood, but I will not use the word. I think we know where we are going in terms of where court is going to pronounce the judgment. But in United States of America, which is very, very federal, Krishna, where states decide what is right or not wrong. For example, states which repealed the adultery laws in recent years include West Virginia in 2010, Colorado in 2013, New Hampshire in 2014, Massachusetts in 2018. So
right,
even America and its states have taken their own time. It's because
right,
when we talk about American democracy, people must understand that there are parts of laws in America which are very, very conservative.
Yes,
America, despite being beacon light of democracy, abortion is an issue in America.
Right.
And it flows from certain elements of Catholicism. So that we have to keep that in mind. In United States of America, Hawaii, North Carolina, Mississippi, New Mexico, South Dakota, and Utah allow the possibility.
Right.
Now, these are the grey areas of adultery. So, giving that from the global perspective, it's not as if, India is far, far behind.
Yes.
The world took its own time, and I think today it's going to be the day when India,
also creates history.
Has done. Now the news is breaking. The majority judgment is that the Section 497 that criminalizes adultery is unconstitutional. Krishna. So the majority judgment is out. It is unconstitutional. The Section 497.
Absolutely.
So adultery has been decriminalized by the Supreme Court of India.
That's right. That's the story that's breaking over here. The latest breaking news update on the adultery law in India. It's a majority judgment, just like the Aadhaar verdict. 4 out of 5 judges choosing to strike down Section 497 that criminalizes adultery in India. And Kartikeya, this is a huge victory for gender equality in the country, and that's the headline that's coming out of it, because the comments made by the Chief Justice of India, Deepak Mishra, makes it clear that this law is arbitrary, and that it's offensive to women. It affects the individuality, the equality and the dignity of women. And Kartikeya, we're now being joined by Justice Mudgal live on this broadcast for this big breaking story, and I'm requesting Kartikeya to stay on as well. Justice Mudgal, thank you so much for joining us.
Yeah.
Go ahead.
Can I come in now?
Go
Please,
ahead.
Can I come in now?
Go ahead.
Yes, 497 only gives a right to a husband whose wife is into an adultery to prosecute the other man. It does not give, the wife is not punished under this section, even as an abettor. Right? That's one. Similar right is not available to a wife whose husband is having a relationship with another woman. So this is gender discrimination. It is based on Article 15 of the Constitution, which says the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. So this is discrimination against women only on the ground of sex, which they belong to, and I think this is wrong. And the court has rightly upheld. Second, I don't think we should give too much importance to laws in America. Please, let us have our own jurisprudence. Though they don't ever look at the judgments which we give. So I think what states have done in United States is pretty, democracy is robust, but some of the laws are pretty regressive. So I don't think we should bother too much about that. Some of the states in US have done it, some have not done it. It doesn't matter. We should forge our own jurisprudence.
Right, Kartikeya.
And Europe has shown the way. Yes, they're far more progressive. They are far more progressive than the United States is.
Right.
And I think this is the bedrock of this judgment, Article 15. Secondly, there is a history behind this. There were women bartenders who were not, women in the hospitality industries were not permitted to be bartenders. And they petitioned as the Delhi High Court, saying that this discrimination is wrong, our career prospects are affected. The Delhi High Court allowed that petition. It came up to the Supreme Court. Supreme Court upheld the Delhi High Court judgment, and that was Article 15 again, giving equal opportunity to women. Similarly, the present principles are based upon, the present striking down is based largely upon Article 15 and 14, which says no equality shall be denied to any citizen under law by the government.
Justice Mudgal weighing in on this big breaking story. Kartikeya, that's essentially I want to request Kartikeya Sharma to also join us in discussing this breaking story and analyzing it along with Justice Mudgal. Kartikeya, that's the headline over here. All said and done, it might be an adultery law, but with this judgment from the court, what essentially happens is a huge shot in the arm for gender equality, gender neutrality in the country.
Sometimes when we look at the larger proceedings in the court, we find that the people who are pronouncing the judgment have taken far more enlightened position rather than the legislative branch of our governance. Now, if you look at the submission, Krishna, if you look at the submission of the Additional Solicitor General Pinky Anand, Center was of the view that it should not be done away with. And I'm joined by my colleague Jessica Taneja from Supreme Court, our legal correspondent. Jessica, just take us through the threadbare aspects of the verdict which has come out before I ask you on the deposition made by the Government of India.
Well, Well, Kartikeya, the Apex Court unanimously has, as for now, the majority judgment says that 497 is unconstitutional and adultery cannot be a punishable offence and it cannot be criminalised. So that is one of the things we're hearing from the court today. The judgment, of course, when we preempted this when we heard the observations during the Constitution Bench hearing. But what is important to highlight is all the judges have made sure to point out the plight of women and how women do not have autonomy and they become mere chattels in a society. And of course, submitting to a patriarchal society where just to protect the institution of marriage, it's a woman who doesn't have the autonomy and always subject to scrutiny.
But Jessica, when we talk about this judgment, the proceedings are also very important. Additional Solicitor General Pinky Anand, they have made the submission that adultery should remain in the Indian Penal Code, arguing that it ensured the sanctity of marriage and was for the public good. The centre also argued that the judgment by foreign jurisdictions that decriminalize adultery should not be taken into account, arguing that the matter should be decided on prevailing social conditions in India. But the judiciary has forced its own way and differed from the submission of the centre and said it is violative of Article 14 and 15.
Interestingly, yes, Kartikeya, not making it a punishable offence, but at the same time making adultery as a ground for divorce. The Apex Court has said that, at least the CJI's judgment did say that it is still a ground for divorce but not criminalised. At the same time, talking about other countries and their outlook towards law such as adultery, the CJI did say that a country like England could do away with adultery law. And one of the forefathers of our constitution and this IPC section, which was framed by them back in the year.
But Jessica, there are certain laws in armed forces, and if you can shed some clarity on it. For example, in army, you have this law which says stealing affection of fellow officer's wife. There are laws, there are rules and procedures, and there have been a number of very famous cases related to it. Does this verdict on adultery have a fallout on the internal rules of the armed forces, Jessica?
Well, Kartikeya, that'll be something we'll have to wait for the detailed judgment when it's uploaded, because right now the judges have just read excerpts of their judgment, important points highlighting, and nowhere did this surface in. So one will have to wait and see as to what the detailed judgment say. It might have mentioned that, it might not, because this was something the court did not really say today, at least.
But then this finally, India gets rid of one of the laws made in 1960s when India was taken over by the Crown after 1857. So imagine, it's such an old law, 1860, and there was no reform which took place. So how will it affect an average person? Just explain that to our viewer. What does it mean when we say it's decriminalized?
Well, Kartikeya, adultery as a law, this IPC section, you can compare it to 494, which is bigamy. Section 494, which relates to bigamy. Now, in bigamy, both men and women are punished if there is a relationship outside marriage. But when it comes to adultery, only the man is punished and not the woman. So initially the argument was, why is only the man punished and not the woman? And then later on, it was when it was compared to bigamy, the court did point out that why is it that only the man is punished, and why should we make it gender neutral and not just do away with it? Because as it is, it doesn't make sense. But at the same time, as you pointed out, the centre was very keen on keeping it, making it stay put, because at this point in time, according to the centre and the submissions we've seen, the government feels that it is important to keep intact the sanity of the marriage, and also whether the factors governing marriage and the way our society is built on such views. So given that point, when compared to bigamy, it only punished men. So that was one of the center of the arguments, but that was taken away later. And now, when it's completely struck down, it can only be a ground for divorce. So if a man is having intercourse with another man's wife, he does not have to take permission, or she does not have to take permission from her husband. So you sort of understand the kind of intricacies this law came with and made woman the subject instead of the man. But at the end of the day, both suffered equally.
Jessica, you stay with me. I think Krishna, very relevant point made by Jessica. It was not only about giving dignity to women, it was also about that in this context, men in certain cases also got disempowered, Krishna.
Yep. That's right, Kartikeya. This law is so archaic. It's not kept pace with the way society has evolved since the year 1860 when this law was enacted. And we were talking about it at a time when this comes in the back of Section 377 and being struck down by the top court. And Kartikeya, you'd remember it was the same thing. The question was whether it is a criminal offence or not. And in this particular case, the 1860 law clearly makes the woman a property of the man or the husband. And that's what judge after judge, if you see, Kartikeya, every judge, Indu Malhotra, Nariman, Justice Nariman, all of them are saying that the days of woman being under the shadow of a man is gone. Those are the words of Justice Indu Malhotra as they're reading out this judgment. So the way this judgment is being delivered and the kind of words, the kind of language that's being used, it's a clear signal to tell the world and to tell India as well that this is 2018. There is no place, this law has no place to exist. And the only caveat here is that adultery is grounds for divorce, but that's the case with so many other countries. So India is sort of this particular striking down. India keeps pace with the laws of the most developed countries in the world.
Reflection of social morality.
Yeah.
Social morality of 1860 was different from social morality of 1960. And the social morality in 2018 will be different from the social morality in 2098. So I think laws have to keep up with the context, which is social morality.
Yeah.
Now, when we talk about social morality, it's about the relationship between men and women. Like Justice Rohinton Nariman makes a very important point. He says, ancient notion of a man being perpetrator and a woman being victim no longer hold good.
Yes.
Now, if you look at the reforms which have been made in rape laws abroad, they make the crime gender neutral. So it is less on gender and more on the axis of power. So similarly, when we say that certain laws have been changed, they reflect the changing social morality, they reflect the way the people perceive them as to be. For example, if you look at some of the comments, in the comments, verdict is one part of it, but when judges elaborate, you understand how they have taken this position. For example, one of the judges read, Section 497 gives husband the exclusive right to prosecute his wife's lover. A similar right is not conferred on a wife to prosecute the woman with whom her husband has committed adultery. Secondly, the provision does not confer any right on the wife to prosecute her husband for adultery. Further, the law does not take into account cases where the husband has sexual relations with an unmarried woman. And then the Chief Justice of India, what does he have to say? It's part of his verdict. He says, adultery might not be the cause of an unhappy marriage. It could be the result of unhappy marriage. This was inconceivable in 1860s.
Right.
But the judges have taken that position, which means that the shift in certain ethical, social issues, they will have an impact on a law. And I think that is the bottom line when we say what is progressive law making.
Yes, and there has been a lot of progressive law making, Kartikeya, over the last couple of weeks. Be it the Aadhaar verdict or this one, or for that matter, Section 377. We have Justice Mudgal still with us on the broadcast. Kartikeya, let's quickly go across to him. Justice Mudgal, the discussion here is how the... Go ahead. Want
me to say, Mr. No, please tell me, since Mr. Kartikeya has already said whatever he wanted to say, do you want me to say something else? Please tell me. You can ask me a question, please.
Justice Mudgal, the question I was going to ask you was that India is doing away one after the other of laws that belong to the colonial era. And, it's taken over 150 years for many laws to be struck down, especially this one. So the moral fabric of the country has changed and the law is sort of keeping pace.
Yeah, I agree with you. No, more than that, moral fabric, it is the judicial outlook which is changing rapidly for the better. And I think Supreme Court has given one progressive judgment after the other in recent times. And this should be applauded by all who are concerned with law and who are all concerned with the citizenry of this country. Let me tell you, all these things, take Aadhaar for instance, while upholding the utility of it, the incursions into privacy have been kept out. Similarly, this verdict then highlights the gender inequality in some of our laws, and I'm sure these laws were made long ago. Ideally, the Indian Penal Code should be rewritten. It was done by a British mindset of the 1860s, and I think it's time to rewrite the entire criminal procedure code as well as the penal code, retaining on some of the good points and getting rid of, because every point cannot be brought to the court and taken time. Let the legislature do this reform and it will be a most welcome thing. Make law simpler, make the procedure simpler, and therefore that will reduce judicial errors.
Right, and Justice Mudgal, if I were to ask you, some of the language that's been used by the five-judge bench in this particular judgment, the adultery law judgment of striking down Section 497, it's a clear signal for gender neutrality and gender equality in the country, and that coming from the top court is said to have ramifications. Maybe there will be other laws that will need to be modified based on this judgment.
Absolutely. There's not only gender neutrality, it shows an openness of mind, a liberal court which is thinking along modern lines as it should, because the constitution mores, constitution norms should change in keeping with the time. It was called social morality by Mr. Karthikeyan, an elegant phrase indeed, but the interpretation must depend on the norms of the time, what prevail, and you cannot live in an era which was more than 100 years old. I think it's time to, therefore, these interpretations coming one after the other are indeed extremely welcome and should strengthen the hands of open thinking in this country.
A lot of judgments have come, for example, the judgment on 377. So why has it happened that progressive law making, which should be part of the legislative agenda, has shifted to the judicial domain? Like, for example, they could have been consistent within the legislature on 377. Judiciary did it. Even in this matter, judiciary has taken the step. When Constituent Assembly was in force, let me complete the question. The lawmakers, the founding fathers, they created modern democratic framework. It's if that it looks as if the judiciary today, as one component of governance, is into reformative lawmaking. The legislature is not doing that job properly.
Well, I put it this way, I wouldn't call it reformative lawmaking, it is reformative law correction. Wherever the laws have been found to be unconstitutional, they are being struck down. I agree with you, there are certain steps which the legislature may not want to take because of its ramifications in the field of politics, in the field of popular perception. However, the court is not guided by populism. The court is only guided by constitutionalism and its interpretation.
So, which means that for an average citizen, yes, there can be pressure of populism on lawmakers, but then that's where the character of good lawmakings come forth. That you should resist it in context of, as you said, correcting the law rather than submitting yourself to certain populism. And this was very, very evident even in the context of Jallikattu of Tamil Nadu. So my question is that all these corrective mechanisms are being left for Supreme Court, because a Supreme Court will go by constitutional morality, not by populism.
Look, that is the distinction between a court and a legislature. The court, I will not blame the legislature alone for going by what the popular sentiment is. They are people, representative of the people, they reflect that. But sometimes such representations, such manifestations in form of legislation do not meet with the constitutional requirement, and the court dehors the principles of or the concepts of popularity, must act only in accordance with the Constitution, and court is not bound to take into account what the popular feeling, if it is not right, may be.
So, Krishna, a very important point made here, that sometimes lawmakers do away or they do not take strong positions because they feel that it might have electoral consequence. But then certain important measures, and that's a second question which will be taken up by a lot of people, because the first part is over, the verdict is out. But then there are a lot of questions to be asked, that how come that certain things which can be resolved at the level of the legislature are forced to go into the judicial domain. Look at the issue of Aadhaar. Legislative matter, resolved by judiciary. Issue of 377, issue of lawmaking in parliament, resolved by judiciary. Adultery, resolved by judiciary. So my question is, has our opinion become so socially, ethically and politically divided that we cannot resolve them through parliamentary mechanism, Krishna? That's the bottom line. Similar matter keeps on going, they keep on going back to the court, and then people say that judicial outreach. But somehow it is also legislative dereliction, Krishna.
That's right. The big breaking story and the big focus here on World is One News is that India has struck down the adultery law in the country. That's Section 497 that pertains to adultery being a criminal offence. It's been a unanimous judgment from the 5-judge bench at India's top court, the Supreme Court, that includes the Chief Justice of India, Deepak Mishra, and they've unanimously called the law as arbitrary and offensive to women. Because keep in mind, this law was enacted in the year 1860 in India under British rule, and this law made it a criminal offence for women adulterers and not for men. There was a clear case of gender bias in this law that has now been struck down. India is free from the adultery law, Section 497. The judgment also makes it clear that adultery is and remains a ground for divorce, so that doesn't go away. What does go away is that it goes away as a criminal offence, and more importantly, the imbalance that the law already had, in which men cannot be called criminals according to the law, but women can be called criminals, that is completely done away with. And it's been a unanimous judgment. It's not a majority judgment. All 5 judges agreeing and speaking in unison in some of the words and the languages they've used. They've said that gone are the days when women are in the shadow of men. And this law takes away the dignity of women, takes away the individuality of women.